This is Asia Ibrahim versus Level 25 at Durango and Pacern Real Estate Group. Okay, folks, this is time and date for trial. And ma'am, are you a witness, co-counsel?
You have two witnesses, besides, she's representing the council.
Okay.
And we have a witness
Okay,
right here.
before Mr. I'm going to have you actually hang out until you're called.
Gotcha.
No, she's
Thank-
gonna, actually, she's gonna, okay, yes, because she represents the council, but she can hang out until she's called.
I'm sorry? She is going to be because I asked her to be.
Okay, yes.
And here's the thing, not that wasn't directed to you. No, you're good. It's to these gentlemen here. And I'm glad you guys are here. So the proceedings in court have involved a lot of casual back and forth. This is going to stop today. This is trial. It's motion practice. We're not going to interrupt each other. Obviously, I'm going to be directing the proceedings, which is why, ma'am, I had you take a seat back there. We have some motion practice that we have to deal with before. Our witnesses are going to be testifying up here. They're not going to be sitting at council table. So I'm going to be dealing with the motions, and we'll proceed that way. Obviously, you guys understand we're not going to interrupt. I had not previously ruled on the motion in limine filed by defendant on April 7th, which was opposed. And I'm not going to rule on it now because it's not ripe. I'm not sure what's going to be introduced because we're starting at square one. I will just caution the parties that anything that was not disclosed in discovery is not going to be allowed at trial pursuant to discovery rules. And so I appreciate the motion. I'm going to wait and see. And you can renew the motion if you wish, if you feel that there's a basis for it. As it relates to your motion, Mr. Ibrahim, about motion to exclude plaintiff's evidence, we talked a little bit about this. And I'm not sure necessarily why you filed this as a civil case as opposed to a small claims case, aside from damages. You don't need to answer that now. But the reason I'm asking myself that is obviously, as you're learning, there's a heightened standard of court procedure, court rules, evidence, and guidelines and things of that nature, which you're subject to because we are in civil court, unlike small claims court. In your motion to exclude plaintiff's evidence, you are essentially arguing, referencing metadata that would be required to show that the photos have been altered. Metadata evidence would require an expert. You have not noticed an expert, nor I believe have you hired an expert, and so testimony about metadata is not going to be allowed. The time to hire an expert and to challenge that type of evidence has passed. The other thing I explained to you is your testimony, the former tenant's testimony about the authenticity of the photos, your photos, and the lack of the authenticity of their photos is better evidence, in my opinion, than metadata. And so your motion to exclude plaintiff's evidence, even though there was no filed opposition, there's no basis in law for me to grant it, so that's going to be denied. And that order will be prepared, and we'll keep a running tally of what orders need to be prepared. Lastly, there was a motion to continue filed. And one moment, sir. That was based on the fact that you claimed defendant disclosed bills and invoices 7 days prior to trial, which has led you to be unprepared because they gave that to you in an untimely manner. Would that be fair to say?
Correct.
Are you still seeking a continuance today based on those bills and invoices?
There's another motion that I filed, so prior to that one, I don't know, did you receive that one? Or was it?
Let me ask you, I want you to answer my question
Yes.
about this motion to continue.
Yes.
I just asked. Are
Yes.
you still seeking to continue based on the bills and invoices?
Yes, at the moment, yes.
Okay. One moment. Do you plan to introduce those? Is it true that you disclosed those 7 days prior to trial?
No, I certainly disclosed them much earlier than that. I can't remember the exact date. My client, we e-served them first. So we usually e-served everything, but then we provided a personal binder of us as is. But we
Right,
served
but-
them in person.
was that in conformity with the discovery deadline?
I believe it was, because we provided every document, everything requesting discovery throughout that time.
Okay, what I wanna avoid, of course, is
I gotta see if there any updated receipts that would be,
you each have 2 hours to present your case if we don't continue this. What of course I wanna avoid is using your precious time arguing about whether evidence was disclosed in a timely fashion. So I want you to be prepared and efficient in responding to that
Yes.
and in making that objection.
Correct. I've seen about a third of that binder.
Sorry?
I've seen about a third of the binder.
You've seen it because it wasn't disclosed to you.
Correct.
Okay. Which will limit the defendant in their case. And I want you to remember, this is your claim where you're seeking to establish, it's a very common claim. You're seeking to establish that you're entitled to part of your security deposit. And that's what the evidence is going to be about. That's what the trial is going to be about. Otherwise, it's not relevant, including your claim of emotional distress.
And more to it, like, how do I say this? Bad intentions on.
Yeah,
like
that they
a
acted,
stop
they had
over
bad
on-
faith.
Yeah,
Yes, that would be part of your security deposit claim in emotional distress, which would entitle you to double of what the original security deposit is. I just don't want us to get sideways from what the issue is at hand.
and defamation of character.
This is not a defamation. You do not have a defamation claim.
I mean, there was claims made to a federal
Did you,
agency.
did you claim defamation in your complaint?
On my first one, I did. On the second one, it's kind of in between. Only because it was in a different district. I did do a small claims originally. I was told it was the wrong jurisdiction.
It is for a defamation claim,
And that's why I said.
but
can we
I did not
combine
see defamation claim in your complaint. I will re-review it.
and ask to join them together.
You cannot now join them together.
No, you already approved it.
To assume your small claims into your civil case?
Yeah, I put a filing for it back in June.
Okay, I'll check the minutes on that, but, the motion to continue is denied for now. If during the presentation of evidence, I learn that there was a violation of the discovery rules, their evidence will be excluded. The remedy's not necessarily a continuance, but it depends the probative value and the relevance and things like that, and how prejudiced you are by the late disclosure.
Your Honor,
So the motion to continue is denied. One moment, counsel. Did you say there was another motion?
Yeah,
Mr.
it
Ibrahim?
was for fraud on the court.
Yes.
Trying to,
That was the 417 motion that I ruled on. It was fraud on the court and to exclude plaintiff's evidence.
correct.
I denied that.
Is there a reason?
Yes,
Is
it lacks a legal basis for me to grant it. I went through this with you. You want it to be excluded because you claim you didn't get metadata.
No, because they put pictures that depict another unit that's.
Right, I went over this with you. I don't find that to be fraud. I find that to, if that's true, to be some level of incompetence on their part, which could benefit you in this trial. Because what you would do with that is you would say, Your Honor, this is where I lived, this is my video of my walk-in, this is my pictures of my move-in, this is my pictures of my move-out. These people can't be trusted, their testimony can't be trusted, they can't even provide the photos of my unit.
Correct.
That is how much of a sideshow these people are. Therefore, Judge, you shouldn't believe anything they say.
Correct.
So that motion's denied, I'm not gonna revisit that motion.
And the fact that the only other reason for the metadata was the fact that they entered my apartment without being given permission, which is a violation to my
That
privacy.
metadata wouldn't establish that necessarily, and you have not noticed an expert to get into metadata evidence, which you shouldn't even be talking about metadata. Metadata requires an expert. And that's just the way it is. You might know a lot about metadata, you wouldn't be able to testify about metadata. You can't give opinion evidence unless you're an expert. Any other pretrial issues?
as far as that motion, small claims, if I remember correct, I think I did a motion to dismiss because of.
That's not necessarily what he's referencing. He's referencing that there was a motion to adopt the small claims causes of action into his civil case, which frankly, I
I
don't,
don't remember that.
that was denied. What date was that denied, Madam Clerk? Okay, last year it was denied. So,
To,
Mr. Ibrahim, you're going to present your case and try to meet your burden on the causes of action claimed in your complaint, okay? So, you each have 2 hours to present your case. My clerk is keeping a running time. You can keep your time if you wish, but the clerk's time is the controlling time. And I can update you gentlemen about how much time you have, okay? Does anybody have any questions before we get started?
Not one, no.
Sorry?
no, ma'am.
No? Okay.
Wait, okay. 2 hours each, you said, right?
2 hours each.
And, okay,
So your cross of plaintiff's witness counts on your time.
yes.
Your cross of their witnesses counts against your time.
I do have one question. If I wanted to do a summary judgment here at the jump, could I?
You want to make a motion for summary judgment right now, right?
I'm saying I could if I would like to.
You can make an oral motion for summary judgment, but for a summary judgment motion to be granted, it has to be supported by evidence. And I'm not taking oral testimony as evidence to your oral motion
but
for summary
oral
judgment.
testimony would be okay, right?
Well, it hasn't been properly noticed. That would be like ambush, because it hasn't been properly noticed. The photos haven't been provided to him or his client so that they can properly and adequately respond. So I'm not gonna allow you to bring a motion for summary judgment. However, would you like to make an opening statement?
Sure,
So stand up if you're gonna make an opening
sorry,
statement,
that's
please.
a question before I do this. We talked about my video, you said I could use it in court, last that we spoke.
Any evidence that was disclosed in discovery
And
Can-
he said that he had received it, so.
can be presented in court. Do we have one moment.